Simply put, all we saw today was the prosecutor asking the witness to express his opinion on certain issues. In fact, quite a number of the questions he asked actually proved our case on behalf of the fugitive offenders. He clarified, for instance, the issue of just one example on the documents that were apparently scanned through. He proved beyond any doubt that the documents that were scanned are not the same documents that were in fact used in the extradition. Save for that, I think I can very confidently say that our matter ended on a high. We expected a lot more coming from the DPP's office, and yes, it's so clear to me that they know they've got problems in their case.
Today is the end of the hearing part of the case, and we are quite happy with the way it has been concluded. We expected maybe more will come out of the re-examination, but you see, we've only spent a morning for the examination, and personally, my personal opinion is that in fact it has destroyed their case further. I think you were able to see there were some concessions being made that the original has got initials, but the scanned copy it doesn't have an initial, showing that, remember, the issue of authentication, that means you don't have an original copy of. So those things, I think they were coming out back in re-examination, and for us, that's why we didn't have too much questions or objections to raise, because we believe it supports our case. It means all the questions, all the evidence that we got in cross-examination has not been rebutted. So we're now prepared to go for the submissions, as my colleague has said. The number of days which have been given are quite sufficient. The issues which we raise in cross-examinations are the issues on which we're going to submit on. So like we were saying, what are relevant offences? You remember in evidence. So now we'll go back to section 5 and say, what does it say? The schedule. Do those offences they found in the schedule? So I just try to summarize those issues and bring them to the attention of the court, for the court to appreciate and make its decision on whether to extradite or not to extradite them. In fact, maybe I should make it clear, it's not the court doesn't extradite, okay? The court commits them to prison, okay, waiting for the minister to extradite. So it's the Minister of Homeland Affairs who issues an extradition order. It's not the court. Or the court that will say that I've assessed the evidence, and to me, I believe there is a case for extradition. Or I've assessed the evidence. To me, I don't believe there is a case for extradition. Then that's why the matter ends. So that's the judgment that we should expect from the court.